Oh, you know, that same this. That sound is me getting emails. For some reason, when I get an email, it's making a sound. Because I notice something. That's what it is. It's like a notification. Well, then I won't know how to get to it, so I don't know why. Anyway, we'll figure it out. It says. See, Judge Walker, you've got Aaron Shutley.
Judge, can we hold that for 1 second? This won't be on our way down.
Sure. See, Mr. Wasserstein, you've got Guadalupe Reyes. Yes.
Good morning.
Morning.
Morning, Judge.
Morning.
Morning, Judge.
That's TRN sound. All right, sir, you Guadalupe Reyes?
Yes.
This is 25 DCCR 1422. This was the final reset, so there needs to either be plea papers or a rejection. What's the announcement?
I'll show him how to do the rejection. I think he was, go ahead, sorry.
Judge, I'm gonna ask for another setting. I know it's in writing and you advised us there wouldn't be any more settings. Since the last setting we had, I've got an investigator. Met with my client a few times at the office. There's some things I'd like to look into before putting it on the trial docket. I don't know if you'll give us one more setting. I would ask for 30 days, Judge. That'll.
Okay, pay attention here because this is one of those subtle courtroom moments people underestimate. When a judge says a case is on its final reset, that's usually code for we're out of excuses and running out of time. But notice something important. The defense attorney presents a legitimate reason. New investigative leads in the legal world, fresh evidence can change everything. The judge gives one last extension. But with a warning attached, translation, this clock is officially ticking.
So typically when I say final, it's final,
I
but this
understand.
is going to be the last final.
Okay.
Okay?
Thank you, Judge.
So this will be, truthfully, you've got to get everything taken care of
Yes,
before
sir.
that next court date. Make sure you stay in touch with your attorney. Y'all go over everything, whatever the state's offer is. Either you come back, you take that offer, or we put your case on the trial docket.
And he's done that without the offer. I think, Judge, he's gotten all discovery. He did ask me this morning about an extension to have his investigator look at some things. I don't have a problem with that because he's taking
Okay.
care of everything else. Your Honor.
Perfect. All right.
Judge, and
We'll see.
Mr. Nichols has hold my hand about if I need to handle rejection,
Perfect.
how to use the tablets.
Okay, well, we'll get you taken care of
Awesome.
next time,
Thank you.
but we'll see you then.
I
Take
appreciate
care.
it, Judge.
Yes, sir.
Thank you. Thank you, Mr. Nichols.
So
He's gonna roll cell phone or the final one. See, Mr. Radford, you've got Marquise Berry.
Yes, ma'am. Fair. You need to set that on the trial docket. I
Did you do a rejection?
think she's already done, because I'm the trial counsel that was appointed.
Has there been any change in?
No, ma'am. No,
All right, ma'am, you're Marquise Berry. And this is 25 DCCR 0882. Ms. Berry is charged with aggravated assault with a deadly weapon. It's like back in March, there was a rejection of a 10-year term in prison, and you want to continue with that and go forward with trial with Mr. Radford. All right, we'll get it set on the trial docket. I do want to make sure, Ms. Berry, that you understand that after today, once your case is on the trial docket, I will not accept this plea agreement unless there's something that comes up that your attorney or the district attorney doesn't know at this point. Otherwise, if you change your mind, you can enter a plea open to the court or to some other plea agreement. Do you understand? All right, we'll get it set on the trial docket. Thank you.
Did you catch that? This is a huge decision point. The defendant is rejecting a plea deal and choosing the uncertainty of trial. And here's the reality. Once a case hits the trial docket, the negotiating power often starts disappearing. It's a legal version of last call. Would you gamble on 12 strangers deciding your future? Or take a deal that's already on the table? That's the pressure these defendants are under.
Maybe, excuse me.
Yes, sir. Aaron Shetley, Ms. Melfino and Judge Walker. All right, sir, are you Aaron Shetley?
Yes,
And Mr. Shetley's case is set, it's a pretrial, set trial to begin with jury selection next Monday. What is the announcement?
Judge, I have spoken many times with Judge Walker about this case. I know that it's obviously getting older on the trial docket. I had also let the clerk know several months ago that I was likely to be out next week, and I let her know several weeks ago I will be unavailable for court. I apologize about that. We are still working toward a possible resolution that may involve a jury trial, but that's something that Judge and I would like to possibly discuss with you a little bit later, but that is my situation for my two trial cases next week.
Okay.
I asked that they.
And we
stay
left
on-
them on today just in case. We wanted
Yes,
to make
because
sure
I-
that there was anything that might get worked out, but if it's not gonna get worked out today, any objection to that getting reset?
If she's not gonna be here, we're ready.
Okay.
And I did let
Wait,
Judge
she-
Walker know.
So we'll just reset it on the next available trial docket. If something works out between now and then, please bump it up and so that we can get it taken care of before that date. Otherwise, we'll get it taken care of that next court day because it is definitely one of the older ones on the docket.
Thank you.
So-
And I've also spoken to the misdemeanor prosecutor who's handling that, and I
Okay.
think we'll try to take care of everything.
This exchange may seem routine, but it's actually revealing a massive challenge inside the justice system: scheduling conflicts. Believe it or not, cases can be delayed for months because attorneys are juggling multiple trials at once. Meanwhile, every delay means more waiting for everyone involved: the defendant, the prosecutors, potential victims, and even witnesses. Justice moves slowly, and sometimes painfully slowly.
All right, stay in touch with Judge Walker. He'll let you know when you need to be back. Thank you. Okay, Mr. Rojas, are you ready on William Bonilla?
Yes.
Good morning. Are you William Bonilla? Good morning. This is, good morning, Mr. Rojas. Clause numbers 25 DCCR 0719 and 25 DCCR 0174. And what is the announcement?
Judge, I think our plan is to enter pleas to the motion, come back to the punishment hearing, and then after that, we'll see what happens with the felon defendant case.
Oh, okay. One of them's, are
One's a
they,
motion, it's a motion to revoke on a misdemeanor. EWI.
and so what are you guys gonna do with the new case?
The motion's based on the new case, Judge, so depending on what you do with the motion, I think eventually we're gonna plead it, but I want to see what happens punishment wise on the motion before we do that.
Mr. Bonilla, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? And thank you. Will your client waive the formal reading of the motion?
He will, Your Honor.
Mr. Bonilla, in clause number 25 BCCR 0174, I have a motion to revoke your community supervision. Shows that you were placed on probation April 14th of 2025 for the Class B misdemeanor of driving while intoxicated. That was a 180-day jail term that was probated for 15 months. Is that correct?
Now we're entering probation violation territory, and this is where things get serious fast. Here's something many people don't realize. You don't necessarily need a brand new conviction to end up back in trouble. Violating probation conditions alone can put your freedom at risk. The prosecution is even correcting the wording on the record in real time because every single word matters in court.
It alleges that you violated your probation. Count 1 alleges that you committed the new offense of evading arrest or detention with the use of a vehicle, May 10th of 2025. And is that true or not true?
Your Honor, before he answers, may I move to orally amend that count to read that the defendant committed the offense as opposed to was arrested for the offense, so that it lines up or matches the
Yeah, that's,
MPRP or the
thank you.
conditions.
No objection.
Okay. All right, so count 1 now alleges that you committed the offense of evading arrest or detention with the use of a vehicle, May 10th of 2025. Is that true or not true?
Not true.
So we're gonna have to come have a hearing with,
It's just a matter of you watching the video, Judge, is all. But yes,
I mean, you'll have to have an officer come to
Yes,
prove it
yeah.
up. Have y'all watched the video?
I have,
Okay.
we have, yes. Ma'am.
Okay. Count 2 alleges that you failed to immediately report to the probation officer that arrest from May 10th of 2025. And is that true or not true?
It's true.
Should you enter your plea of true to count 2 freely and voluntarily?
It's true.
And because count 2 is actually true. All right, then I'm going to find that you entered your plea of true to count 2 freely and voluntarily, find that count true, find sufficient evidence to not find you guilty, to revoke your probation. I'm going to reset your case for sentencing. And it sounds like we just need, unless there's some agreement that If it's mainly just the video, if you guys agree that he can present the video without having an officer having to come lay that foundation, great. Otherwise, I would think still an 11 o'clock with just
Interesting legal strategy here. Instead of bringing an officer to testify, both sides are discussing whether video evidence alone can do the job. This is modern courtroom efficiency in action. But here's the bigger question for you. If you've seen video footage with your own eyes, should that automatically be enough evidence? Or should a witness always have to explain what you're seeing?
one witness would be plenty, correct?
Yes, ma'am.
All right,
Judge.
y'all discuss that and then I'll get an updated pre-sentence report and we'll see you back at sentencing.
All cell phones out of sight during the proceeding. Like, don't let me see them. You put that phone away.
They're recording.
I don't think so. They're going to talk on.
Mr. Rojas, you have David Calderon. Good morning, sir. Are you David Calderon? And this is 24 DCCR 1428. Mr. Calderon is charged with unauthorized use of a vehicle. And what is the announcement?
Judge, we're asking for another announcement document. We do have a discovery in the offer. I have relayed an offer to Mr. Calderon. However, it was the wrong offer. Somehow my offers got mixed up in the file. So now
Okay.
I need more time to go over the correct offer and give him time to look at all that.
No, no objection, Judge.
All right, so I'm going to reset it one time. I know you were just recently appointed, but Mr. Calderon had to come here quite some time, so the case is very old. So if you can try to get with Mr. Rojas, make sure you go visit with him before the next court date so that we can get an announcement. All right, you're free to go. Jamie, Carol, Mr. Rojas? Good morning, ma'am. You're Jamie Carroll. This is 26 DCCR 0286. This Carroll is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
Judge, I spoke with Ms. Carroll on the phone briefly last week. We haven't had a chance to go over all the discovery. I can give you that announcement about the able to do that.
Any issue with something? No.
No, Judge, I've sent two alternative offers to Mr. Rojas.
So, Ms. Carroll, I'm going to reset your case about 30 days. You need to make sure and call, make an appointment to go visit with Mr. Rojas. You can go over everything that he has and we'll get an announcement at the next court date. Don't wait till right before that court date. Make sure you call him, go see him plenty of time before that, okay?
Yes.
All right, free to go. Gabriel Pena. Mr. Rojas. Good morning, Ms. French. Good morning. Good morning, sir. You're Gabriel Pena.
Yes.
And this is cause number 26 DCCR 0064. Mr. Pena, you're charged with the third-degree felony offense of failure to comply with sex offender registration requirements. And that's from September 27th of 2025. Your indictment alleges that you were previously convicted of indecency with a child by exposure, third-degree felony, December 2nd of 1999. That after that was final, you were convicted of failure to report a change of address, a third-degree felony, May 22nd of 2014. And what that means, sir, is that if you go to trial and you're found guilty, the minimum punishment would be 25 years up to 99 years or life in prison. Do you understand?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. I'm sorry, no, I don't. I have a document entitled plea bargain rejection. It shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 20-year term in prison. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are. And do you understand all of that? Thank you. And so do you want to reject that offer and have your case set for trial? All right, I'll get that taken care of. Mr. Pena, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Not. Sure, I could. Answer that. Is it to my?
To your benefit? Is that what you're trying to ask? So it's really up to you. If you want to keep Mr. Rojas, then he can prepare for trial and get ready. Otherwise, I'll appoint a different attorney today and they'll get prepared. Mr. Rojas is just here a lot, handles a lot of cases, and a little busy, but it's up to you. If you want to keep Mr. Rojas, that's fine.
Which?
It's completely up to you.
Which you? Opinion.
It's really, yeah, it's really up to you. Mr. Rojas is fine either way. So if,
Which?
And we have a few minutes, maybe pop.
yeah, sure. And you can just let me know
Okay.
and then I'll either y'all visit for a few minutes and then he can let me know what your decision is. Okay?
I'm so sorry, excuse me.
Darius Sparks. Good morning. Are you Darius Sparks?
Yes.
And Mr. Sparks is charged with assault, family violence by impeding breath or circulation and cause number 25 DCCR 0754. And what is the announcement?
Judge, I think we have a resolution this morning. May I first permission have the name Rainella Gage called to see if she's in the courtroom today, then I can.
Rainella Gage.
Yes, ma'am.
Rainella Gage. Is there a Rainella Gage? If you'll call the name, please. Rainella Gage. Robert Simon.
No response, Your Honor. Judge, the record may reflect that I have reached out to Ms. Gage. I've sent her multiple letters. She did call back. I returned her call. She was in a meeting that said she would call me back. She has yet to do that. I just wanted to see if she was in the courtroom today, but I do think we have a resolution. My court will allow him to participate in the bid program, but this case to remain pending in case he does not successfully complete that and a determination of it should dispose of it.
And how long is that program?
6 months.
Should be no more than 6 months, and we could probably get him signed up the first week of July. We could maybe do a 90-day status check on how he's
I
doing.
definitely want to
if
make
he's doing-
sure. So here's the thing, Mr. Sparks, I'm going to reset your case and what I'll do is I'll do a 90-day reset. But I'm ordering you to get signed up for that bid class at the very first available class. Because this is a great opportunity, okay? If you take this class and do everything you're supposed to successfully complete it, it sounds like your case is going to get dismissed. You can't get a better deal than that.
Yes, ma'am.
But here's the thing, if you miss the class or some reason get kicked out of the class or you're not going like you're supposed to, I'm not going to put the case off any longer. It means you're going to be back here facing this case here in court, okay? So it's very important you do everything you're supposed to. All right, thank
Judge,
you.
would you mind still admonishing him as to the no contact during this?
Yes, so you have, as part of your bond, you're still on bond now and you'll be on bond this whole time. So you still have to follow all of those rules.
Yes.
And one is that you have absolutely no contact or communication with Rainella Gage. That's in person, that's sending messages, that's any type of communication. Do y'all have a child together or anything like that? Okay, so there's absolutely no reason for you to contact or communicate with her. That would be an immediate violation of your bond. Obviously, the same deal that you're getting right now would be off the table. You understand?
And this might be the biggest opportunity we've heard all day. The judge is essentially saying, complete this 6-month program successfully, and this case could disappear entirely. That's enormous. But notice how quickly the tone shifts: one missed class, one violation, one attempt to contact the protected party, and that opportunity evaporates. Courtrooms are full of second chances, but they're almost never unlimited. The real question is, will he take advantage of it?
Okay, we'll see you back in 90 days. Talk to Mr. Rojas. He'll let you know. He'll get with Ms. Malfino when that class starts and how to get involved in all of that. Okay?
I'll give you a call.
Whitley Shepherd, it's a sentencing, Mr. Rojas.